secret is revealed that I started here as an assistant. Thank you very much for the invitation to this event. I want to say that we have heard Deutsche Telekom asking for repeal, and I think over the last year all trade association and industry have questioned the work of the European Commission, whether or not this ePrivacy directive is still necessary or not. I'm personally, I guess, more a realpolitiker, and have not expected that the Commission would reveal the ePrivacy directive in its reform. A couple of reasons, of course. It is a different directorate from DG Justice, who proposed the General Data Protection Regulation. It's a different fundamental right that is aimed to be protected by the secondary law. And last but not least, there has been an enormous group of stakeholders in this debate, like the EDPS, who have asked for keeping this directive alive and even expand it to OTTs. I want to remind people just that when we started the discussion on the General Data Protection Regulation, it was exactly the same services that are now in the expansion scope debate that have been put up front as a reason for the reform of the General Data Protection Regulation. I think it's a good reminder that we're talking about the same services. When you think about the ePrivacy directive and what it means to secure the confidentiality of communication, it is primarily used as prohibiting the interception, the access of communication, largely by third parties. That is why we also have an exception for law enforcement in the directive on legal grounds. I compare these, the transmission of communication and the provision of a service in the communication age, like the post officer who delivers my letter to me and my personal assistant who opens the letter to help me organize my work. So if you think about what services like web-based email do these days, it is so much more than only transmitting the communication content. These services nowadays are indeed personal assistants. They help make your life easier. They help you with spell checking. They help you with not forgetting the attached document. They help you not to have your inbox filled with spam, and they do lots more. That is currently a big question mark in the regulation as proposed. Another thing is that communication as such has tremendously changed. What the regulation or what the Commission seems to have in mind so far is regulating what they see or have seen in the past. Communication will evolve very, very quickly. We see bots appearing in all sectors that have an easier communication tool with their customers. We see services like hologram that will totally change the way we communicate. We will communicate much more with voice in the context of our computers. So there is tons of different areas that will change. And that needs to be considered when we are thinking about that. I'm glad that Judge Calvin has already made a couple of suggestions, in particular when it comes to services. Let me just ask a couple of questions that we are looking at while we are now evaluating this proposal. And I may want to say as well, it was rather difficult to explain my colleagues, around 300 attorneys and engineers that are currently full-time busy with implementing the General Data Protection Regulation or for our different services, to tell them more is to come. And we have made already some comparison between the General Data Protection Regulation and the ePrivacy Regulation. One of those is that the switch from protecting communication to protecting communication, processing of communication data, probably in an effort to align with the General Data Protection Regulation, makes it a huge overlap with the personal data protection that we are already seeing in the services. But when you then look at the framework and for example, the legitimate interest, the consent that is required, there's a huge difference. So we would think, going back to my comparison with the post officer and my personal assistant, there needs to be a difference between the network that is transmitting the data and the service that is delivering the service. There's also a difference between where the data is in transit or where the data is stored. Again, here we have probably to clarify what this regulation is for and what it is intended for. I would also suggest that the Parliament invites not only the OTTs or the telecom sector, but basically all sectors, because with the expansion to ancillary communication features, you will actually have expanded the whole scope to every information society service that is on Earth, on the planet, available these days, because all of them are incorporated communication features these days. Also, you may let me also say just a couple of things about the consent it came. There is a consent requirement by all end users. That basically makes spam filters impossible, because you really can't ask for the consent of spammers before you actually evaluate whether an email is spam or not. You have onerous consent renewals. You have a deletion requirement after transmission. So all these things make basically normal services impossible to operate. Last, there's also replacement of the cookie rules. I have some experience with do not track and tracking protection lists that we try to insert in the market. The change of those rules and putting the burden on the operating system will basically not work, and I'm very happy to explain the experience we have made with this on a voluntary basis. And my last point, just to make the list longer, is the jurisdiction. So we have the Article 11 that is the normal exemption for law enforcement, and it's of course national law, and that worked quite well for the telecom sector. The telecom sector is naturally operating per country. They have their equipment in each country. That is not the case for OTTs. And what that means for law enforcement is not clarified either in national law currently, nor in the ePrivacy regulation. There will be enormous pressure on the jurisdictional conflicts that we see in many law enforcement situations. And the Commission has not dealt with it in this directive or regulation. We hope that at least in the Parliament we can clarify these problems occurring. So with this, I'm hopeful for the fruitful discussion. Thank you.